Issue that appeared before the Federal Court of Appeals yesterday are the Haitian refugees that are in Guantanamo Bay, Cuba, those who have tested HIV positive, entitled to counsel during the course of their political asylum hearings. Now, we want to make a quick correction. We said a moment ago that a lower court had ruled they were not entitled to counsel. In fact, the lower court had ruled they are entitled to counsel. The INS was challenging it yesterday before the Court of Appeals, asking that essentially to be overturned.
We believe in certain due process in this country. We have a rule of law, and we do believe that people should be entitled to counsel. And it is troubling, in fact, that the United States government has taken the position that when you have people who have been stopped and have been taken to a United States naval base in Guantanamo Bay, Cuba, that they should not be allowed the right to counsel. And it is really quite insensitive, as you say, and quite troubling.
Well, some comparisons could be made. I mean, the United States has always been sort of the world guardian, at least in this century. It went over and helped in the defense of a very difficult position during the Iraq War and took a leading role there. Here we have individuals who claim that they will be persecuted, executed, punished, tortured if they're returned to their native country, and the United States won't even afford them counsel. Is that morally inconsistent to you?
I find a moral problem with it, and I think we as Americans, certainly, who do promote democracy and to promote the rule of law, should definitely be the ones to take a lead on this and say that certainly Haitians and anyone else who comes who's seeking asylum in this country certainly do have a right to counsel and have a right to an attorney. There is no irreparable harm that will be served upon the United States government if these people do have counsel.
Well, is it discriminatory because these individuals who they are challenging, who they say should not have legal counsel, have tested positive for the HIV virus? Isn't that sort of medically discriminatory?
Well, there is this medical exception that people who do have the HIV virus, there is an issue on whether or not they should come into this country. However, there is also a waiver that you can get if you can show that, for instance, you have family in the United States, or there are other reasons for which you should be, for humanitarian or family reasons, brought into this country.
Well, it seems as though those individuals need counsel more than anybody else.
Absolutely. Those are the ones. And the people that we are talking about who are in Guantanamo Bay, who have tested positive for the HIV virus, are people who have been screened in. And this is a big distinction to be made between some of the other individuals. These people have passed a preliminary hurdle. The United States government itself and the INS have found that these people do have a plausible claim for political asylum, so that they already have passed this first initial hurdle. Now they are in Guantanamo Bay, and all they are saying is that they should also have counsel to help them to see if there are maybe a waiver that they qualify for, even if they have the HIV virus, that they should be brought into the United States.
All right. One quick question before we break away for a moment. What is political asylum? How do you define it?
Political asylum is when you come into a country as a refugee because you have fear of persecution if you were forced to return to the country from which you are fleeing. So that you are coming into this country as a refugee because for political reasons, not economic reasons, because you have a fear that you would be threatened, that your life is in danger if you are forced to stay in the country.
So if I'm a refugee, though, and I come before the INS and I say, I'm going to be tortured or put to death if I'm returned to my native country, how do I prove that? Is it just my word, or do I have to get documentation? How do I go about doing that? After all, I don't want to go back to the country from which I came to get that proof.
That's right. In many cases, it is very difficult to prove. You don't have eyewitnesses. You don't often have people, as you say, you can't go back to your country and get the documentation that would prove your case. So often it is a matter of credibility, and you're making out your case through your own word. But there also is affidavits you can get from people in support who can talk about the situation in the country from which you are coming. For instance, I have a case in which I'm representing a Haitian to get political asylum in this country. And I have contacted many experts who know what the current situation is in Haiti, that people are being tortured, that people are being threatened, based upon certain factors. For instance, the group that they are a part of. If they were an Aristide supporter, they may be targeted more than someone else. If they came from a certain region of Haiti, if they are of a certain political persuasion or worked in a certain kind of field which the government may feel more threatened by. So you are able to prove almost through circumstantial evidence that there are a group that you are pertaining to based on your religion, based on your nationality, based on your political ideas that make you more of a target for political persecution than anything else.
All right. Well, we're going to break away for just a moment. When we come back, we'll take you inside the courtroom as it happened yesterday. The arguments from both sides, the INS and those representing the Haitian refugees before the Federal Court of Appeals. Don't go away.
Welcome to America's favorite gathering place, where everybody knows your name. And they're always glad you came. Introducing the Cheers collection on video cassette, new and only available from Columbia House Video. Now you can be a Cheers regular anytime you want. You'll see Sam and Diane melt the ice.
You know, I always wanted to pop you one. Maybe this is my lucky day, huh?
You disgust me. I hate you.
Are you as turned on as I am?
More.
Watch Carla serve up more than drinks.
We beat him up, strip him, take his money, and put him on a bus.
And see Norm and Cliff trade shots.
I have impossibly high standards for a woman.
Yes, she has to like you.
Call now and belly up for all the laughs at Cheers, starting with your first 3-episode video cassette for only $4.95, including the classic opening episode, yours to own for 10 days risk-free. See a master bartender at work.
I am on a top-secret mission for my...
You are an idiot.
No, that's just my cover. I thought you said that you weren't going to call me stupid now that we're being intimate.
No, I said that I wouldn't call you stupid while we're being intimate.
No place serves up more laughs than Cheers.
It's a romantic bar. As many people fall in love here as get sick.
What do you look at this? For a good time called Diane Chambers. Thank God they got the number wrong. Hey, I got it right off your application. I can no longer hold my tongue. Want me to do it?
To order, call this toll-free number. You'll relive the magic that made Cheers America's top-rated, Emmy Award-winning comedy series, complete uncut without commercials. To get your first Cheers video, have your credit card ready and call this toll-free number. Credit card orders only, please. There's always something funny brewing at Cheers.
Welcome back. Before we step inside the courtroom, what happened yesterday before the Federal Court of Appeals, we want to tell you about who is arguing here. First of all, the INS is bringing this petition before the court, asking them to put a stop to an earlier ruling by a lower court federal judge that said these Haitian refugees are entitled to counsel. And so the first up is the United States government being represented by Deputy Attorney General Stephen Valentine. Now, normally he practices in Washington, D.C., but this case was held yesterday in New York Federal Court of Appeals, and so Mr. Valentine is 36 years old, and as we say, a Deputy Assistant Attorney General, has been since 1988, with a law degree from Indiana University School of Law, has to really be formally accepted by a New York court. He's only licensed in Washington, D.C., and perhaps a few other jurisdictions, not among them New York. So he is admitted pro hoc vici. And Carol Schlitt, what does that mean and how is it done?
One is admitted pro hoc vici, which means admitted really for this term. And what happens is an attorney who is admitted to practice in another jurisdiction must be introduced and ask the court's permission to argue in this particular case, in this particular jurisdiction. And courts will regularly allow you to be admitted just for this case, for the purposes of this proceeding, to come in and argue, even if you're not a practicing attorney in that jurisdiction.
All right. Scott Dunn, who's a special assistant with the U.S. Attorney, does the introduction here, the pro hoc vici for Steve Valentine. Let's listen.
morning, Your Honors. My name is Scott Dunn. I'm a Special Assistant United States Attorney from the Eastern District of New York. I'd like to introduce to the court this morning Stephen Valentine, who, with the court's permission, will present defendant's motion. Mr. Valentine is a Deputy Assistant Attorney General from the Civil Division, Department of Justice. He's been with the Department of Justice since 1987. He's a member in good standing of the Illinois as well as the D.C. Bar. And we would respectfully move this court at this time for his admission pro hoc vici. Thank you, Your Honor.
Thank you, Your Honor. May it please the court. 10 weeks ago, in the case of Haitian Refugee Center versus Baker, the United States Supreme Court granted a stay on January 31st of the preliminary injunction entered by the district court. That preliminary injunction was substantially the same one as the one that's before you today. It was predicated on the First Amendment. It precluded repatriation of interdicted Haitians until we granted access to counsel. And subsequent to the Supreme Court granting that stay on January 31st, the 11th Circuit ruled in our favor on the merits with respect to the First Amendment, and cert was denied by the Supreme Court. Now, essentially, an identical group seeking to offer counsel to interdicted Haitians has gotten essentially the same injunction reimposed for a subclass of the class that was recognized in the HRC case. First and foremost, because this injunction is as baseless as its predecessor injunction, we're asking this court to do what the Supreme Court did and grant a stay. The only meaningful difference between the preliminary injunction that has been revived by the district court in this circuit and the one that was lifted by the Supreme Court on January 31st is that this injunction is predicated not only on the purported First Amendment rights of the organization to offer counsel, but also on the supposed Fifth Amendment rights of individual Haitians to counsel. This Fifth Amendment right violates squarely the Supreme Court's principle as enunciated in the Landon versus Placentia case, a 1982 decision in which the Supreme Court said categorically that aliens outside the United States have no constitutional rights with respect to their applications for admission to the United States. We would submit that that's black letter law. It flatly contradicts the notion of a Fifth Amendment right, and a Fifth Amendment right cannot be seen to offer any support to the preliminary injunction in this case.
Mr. Valentine, so that I understand the context in which we're here. If we grant your application and vacate injunction, grant law, or state injunction, I assume it's the government's intention to send them back immediately and thereby moot the remainder of the problem, if there is one.
Your Honor, if the stay were granted, it would be the intention of the government to repatriate any Haitians who are medically excludable in this class, who have been given their second interviews and who have been determined not to be refugees.
So your argument to us is, let's get it over with. When it gets up here on appeal, we're going to have to reverse in any event, and there's no reason to wait until that time.
Absolutely, Your Honor. And in addition to...
Is there any harm done by waiting?
Yes, Your Honor.
Before you get started on what I'm sure I'll go here, we have substantially the same situation here as we had last motion in this last. You asked for an expedited appeal as well as a stay. Why can't the expedited appeal take care of that if we set a closed time schedule?
Your Honor, an expedited appeal would not ameliorate the serious irreparable harm that we see. Our experience has been with the Haitian...
You want an expedited appeal?
Yes, Your Honor, but it does not obviate the need for a complete and immediate stay, and this is why. Our experience has been with the Haitian Refugee Center case and with this case is that developments in Haiti, namely the outflow of migrants taking to sea in unseaworthy boats, is very sensitive to judicial developments. Already in April, the rate of Haitians leaving Haiti in unseaworthy boats is triple the rate in March. In fact, yesterday, 566 Haitians were interdicted, and that figure is based on a Coast Guard headquarters phone call that we had this morning. Yesterday was the largest number of Haitians interdicted on any single day since the Supreme Court lifted the stay on January 31st. And again, the rate so far in April is triple the rate in March. Now, what has happened? The district court entered a TRO in late March and entered a preliminary injunction early this month. People on Haiti are getting the word that once again there is a judicial restraint on the ability of the United States to repatriate at least some of the Haitians involved.
And you want us to send a message? Is that it?
Well, I think the Supreme Court sent a message, Your Honor, on January 31st. When the Supreme Court...
Didn't seem to do much good if what you're telling me is so.
Well, it did, Your Honor. Immediately in the days following the Supreme Court's grant of our stay on January 31st, the United States began repatriating Haitians by the thousands, and we did see a substantial drop in the numbers. The numbers dropped substantially in February, substantially in March, and now in April they've tripled because, once again, there's judicial involvement. It's important to note exactly the context of the Supreme Court's January 31st action. When we went before the Supreme Court, the district court had entered a preliminary injunction predicated like this one on the First Amendment. We asked the 11th Circuit for a stay. The 11th Circuit did not act on our request, and so we went to the Supreme Court and we asked the Supreme Court to take the extraordinary step of reaching down past the 11th Circuit to the district court and entering the stay. When the Supreme Court entered that stay, it knew that when it gave us our stay, we would immediately begin large-scale repatriations of thousands and thousands of Haitians. They knew that for those Haitians repatriated, the case on the merits would become, in effect, moot. So the Supreme Court took the extraordinary action of granting a stay and allowing these repatriations to go forward. And why did they do that? They did that because they recognized that the First Amendment-based stay of the district court was utterly groundless in law. There is no First Amendment right of access on the part of an organization to foreign nationals held on a military basis leased by the United States from a foreign country. Our submission is that the preliminary injunction in this case is the same one that the Supreme Court lifted, albeit with a subclass instead of the whole class. And in addition, they've added, the district court has added the Fifth Amendment as a basis. And our submission is that that cannot be a basis in view of the categorical statement of the Supreme Court in Langdon v. Placentia in 1982.
Whether or not we grant the stay, we probably should expedite the appeal in any event.
Yes, Your Honor.
When can you be ready?
We proposed a briefing schedule, and I understand that counsel for the other side does not object. That calls for our brief to be filed, I believe, this Friday. Their brief to be filed 1 week later, our brief a few days after that. We would ask leave to file the appendix on May the 1st, and we suggested that oral argument on the merits be held during the week of May 4th.
All right, why don't we hear from the opposition?
Well, a very brief argument by the petitioner here. The United States government, being represented by Stephen Valentine, who's a Deputy Attorney General out of Washington, D.C. What is curious about it, before we talk about the content, Carol Schlitt, is that this isn't what normally our viewers see, which is witnesses on the stand or at least oral argument. Three judges sitting here, because there are three judges who sit on the Court of Appeals. Right. And they pose questions, they interrupt him, they throw him off track. It's very difficult to argue on an appeal. Yeah.
This is your kind of classic appellate argument. Here you have a panel of three judges, as you say, who are there. Basically, these are questions of law. You are not talking, as you do at the district court level, of questions of fact, and you don't have the kind of procedure where you would be placing witnesses on a witness end and then asking a direct exam and a cross-examination and having that kind of discussion of fact and law. What's now happening is really the mere questions of law, and the judges are really acting as you would almost see like in a moot court procedure, where you are basically throwing as you say, throwing them off balance, asking them questions and trying to get at the issues of law.
Sure. Now, the judges have in front of them exactly what we have in front of us, and that is the petitions that were filed here, the responses and so forth, asking the judges to make a decision here based on the following facts that we've outlined. And they also cite the law. The judges also have law clerks who have researched this for them ahead of time. You used a clerk for a judge yourself.
Right.
So they're well briefed before they ever walk into this courtroom.
That's right. They have usually at least 3 law clerks who are working in chambers, who are researching the law, who have gotten the briefs from both sides in advance, who have looked up the cases, and who have actually done often a bench memo, have actually prepared a memorandum. I clerked a year ago for Judge Ileo Glasser in the Eastern District of New York, who just recently finished the Gotti case, and had the experience of actually working in chambers and doing just that, researching the law for the judge and also preparing a memo in advance so that the judges can read that as well as your the briefs.
Thus, the rather quick questions.
Yes, they are very well prepared, and it's a hot bench.
Well, what about what Mr. Valentine said? He said the United States government will suffer irreparable harm unless you issue this order putting a stop to the legal counsel for these Haitian refugees. What is the irreparable harm?
Yeah, I find that very curious. I'm trying to understand, in fact, what the government's harm is going to be. I think they may be arguing that the entire procedure of interdiction, which is going out with the boats, getting the costs of the Coast Guard cutters, having to go and actually get people, stopping them in the high seas, returning them, taking them over to Guantanamo Bay, the costs of putting up tents on this naval base in Cuba. Perhaps they're talking in terms of the entire cost of the interdiction procedure, but I don't think that's really at issue here. What they're really talking about, I think what the plaintiffs are asking is simply a matter of providing counsel for people who are there, and I'm not exactly sure what the terrible harm is to the U.S. government.
Well, reading through some of these documents, it seems as though the United States government, Mr. Valentine, is saying that once you grant these people counsel in Guantanamo Bay, Cuba, a place that is not territorially the United States, not technically speaking, then all of a sudden it's going to send a signal to everybody in Haiti to start jumping in boats and risking their lives to come over to the United States, which may be stretching the imagination just a bit.
Yeah, that is what I think the government has been arguing is called a magnet argument or a pull factor, that what the United States government, what the U.S. does in terms of its decision with the courts will actually pull people from Haiti to the U.S. because they're going to realize, oh my God, they're going to get counsel or they're going to have a chance to come into the United States, and that this will pull more people into our shores. What they're not considering are the push factors. What is actually going on in Haiti? We haven't really talked yet about what the situation is there, but it's been terribly destabilized since the coup in September of '91 and the overthrow of the first elected president, the first Democrat-elected president in Haiti. And Haiti is also the poorest country in the Western Hemisphere. It is the most densely populated, poorest country in the Western Hemisphere. And so we haven't really talked about what these people are fleeing. I mean, not only the poverty, but also the terrible sense of persecution, that people can go into their homes. So I think
let's talk about that when we come back from commercial break. We're going to be showing our viewers the other side, those who represent these Haitian refugees, the advocates for them, when we come back.
Professor at law school, member of the Bar of Connecticut. At this time, I'd like to move this mission forward.
Here's a look at what's coming up on CourtTV.
legs.
Thank you.
How do you get them?
I used to do aerobics till I dropped. Then I found Thigh Master. Every single time you squeeze Thigh Master, you strengthen and tone right where you need it. So it's easy to squeeze your way to shapely hips and thighs.
I thought I'd never fit into these jeans again. Thank you, Thigh Master.
I recommend it and use it.
The secret to shapely thighs is exercising these muscles with just the right resistance. This balanced resistance coil is designed to give you results quickly and comfortably. Want to tone your upper chest and arms? Thigh Master will give you excellent results. Thigh Master. We may not have been born with great legs, but now we can look like we were.
To order your Thigh Master, call 1-800-641-3377. Have your credit card ready or send check or money order for $19.95 plus $4.50 for shipping and handling to this address. No CODs, please. If you are not fully satisfied, return it in 30 days for your money back. Plus, if you call right now, we'll also send you Suzanne's Slender for Life plan absolutely free. Call now for quick delivery.
Hello, everyone. With a Court TV docket report, I'm Peter Thorne. Coming up today at 10 o'clock Eastern Time, Court TV will continue airing a hearing where a judge is being asked to throw out the conviction of Wayne Williams. Williams has been found guilty of 2 of the Atlanta child murders. Civil rights lawyer William Kunstler claims fiber evidence was tampered with in the original trial convicting Williams. Williams' attorneys also claim they were never given access to evidence suggesting the Ku Klux Klan was involved in those murders. Williams was found guilty in 1982 of killing 2 young men. He was linked to some of the 27 other deaths of mostly young black males who were killed between 1979 and 1981 in Atlanta. And at 12 p.m. Eastern Time, we will resume live coverage in the police brutality trial from Simi Valley, California. 4 Los Angeles police officers charged there with beating driver Rodney King on March 3rd, 1991. After a car chase, King was pulled over by police. The arrest was videotaped by a man from his balcony overlooking the street. Now, the prosecution is now in the process of calling its final rebuttal witnesses. It is likely the testimony portion of the trial may end today or tomorrow. That is a Court TV docket report. I'm Peter Thorne.
Every week, Barron's arrives to an unusual reception. Readers plow into it in search of undiscovered values, emerging stocks, and market insights. A fresh issue of Barron's doesn't stay fresh long. And that's the beauty of it.
Subscribe now to Barron's and get 13 weeks for only $28 with a money-back guarantee. Call toll-free 800-641-3377. That's 800-641-3377.
In 1982, Wayne Williams was sentenced to life in prison for murdering 2 Atlanta children. Williams was linked to 22 similar cases which were closed. Now, allegations of a secret file implicating the Ku Klux Klan has Williams hoping for freedom.
I knew that the Klan was active in the state of Georgia in 1981.
Was this investigation blown?
Watch this dramatic story unfold this week on Court TV.
Welcome back. We're going to resume this morning what is a Court of Appeals argument in New York. The story begins actually in the Caribbean, though, as we had mentioned earlier, in Haiti, December of 1990. It's when Haiti held its first fully democratic election. Voters selected Jean-Bertrand Aristide as its new president. It lasted about 8 months. Aristide was overthrown in a military coup in September of 1991. That was followed by chaos, much violence throughout the island country. Hundreds were killed. Thousands were tortured and punished because of their political beliefs. And so many Haitians chose to flee the country in very overcrowded tiny boats, risking their lives in the open ocean, hoping to gain political asylum in another country, possibly the United States, rather than face the consequences of staying in Haiti. About 18,000 of those who fled the island were picked up by the U.S. Coast Guard. 10,000 were detained. They were denied eventually the chance to seek political asylum and were sent back to Haiti. More than 4,000, though, have been allowed to enter the United States formally to apply for asylum. There are some 3,000 that are being held in custody at the U.S. military base in Guantanamo Bay, Cuba. They're also awaiting hearings. And today we're focusing on a very small group of Haitian refugees among those in Guantanamo Bay. Somewhere between 200 and 400 of them have tested positive for the AIDS virus. And because of that, U.S. law prevents them from entering U.S. territory while they await their immigration hearings. So they're in a holding pattern down in Guantanamo Bay. And the conflict is as follows. The Immigration and Naturalization Service, the INS, has claimed that these HIV-positive refugees do not have the right to an attorney. The INS argues that they are foreigners being tried on foreign soil, Cuba, not here in the United States. That may be a very technical argument. And those who are standing up for the refugees say, indeed it is, and it's very unfair. If refugees in the United States have a right to an attorney, then so should those who are being held on a U.S. base awaiting entry into the U.S. Now, yesterday the argument was made in front of 3 judges who sit on the Federal Court of Appeals. We just heard the argument by the INS. A lower court had ruled that the refugees are entitled to counsel, so the INS is asking this Court of Appeals to put a stop to that earlier order. Now, Carol Schlitt, what is the persecution here that these refugees face? What is the political status of many of these individuals if they return to their native country?
I think many of these individuals fear that they will be killed if they are returned to Haiti. The persecution is death. The persecution is torture. In many cases, these people have had family members who have been killed or have worked with people who have been killed and have come to this country because they themselves are afraid for their own lives. In many instances, I know that people who have come to this country seeking political asylum have been in hiding for many years, sometimes years, where they have not been able to work, where they have not been able to lead a normal, protected, productive life.
And that's the case with your client. You represent a Haitian refugee.
I represent a Haitian refugee seeking political asylum here in the United States. I am a pro bono attorney for the Lawyers Committee for Human Rights. And what I am doing is representing this person who came actually before the coup, before September of 1991. He came here because his cousin, who he worked with as a literacy worker in Cité Soleil, which is a very small, poor slum next to Port-au-Prince in Haiti, he had been working, teaching literacy. His cousin was murdered by the Tontamacoutu. It's a paramilitary group which basically had been the secret police under Duvalier, and they had both tortured and killed his cousin, putting like acid in his eyes and stabbing his cousin, and he was then I think basically they went to his home as well and tried to get him and said, you know, we want to know the whereabouts of other people who've worked with you. He was very threatened and then went into hiding for a year and a half. He came to this country after attempting twice to get out of Haiti.
So if he returns to Haiti, his life isn't worth very much.
That's right.
Yeah. Well, much is the same for hundreds of Haitian refugees who are seeking political asylum in the United States, and they are being represented, most of them for free, by a group known as the Haitian Centers Council. It's out of Yale, and they are now going to make the argument on behalf of the Haitian refugees, and the individual's name, and we might tell you just a bit about him. His name is Mr. Coe. I believe his name, Harold Coe, 37 years old, Yale law professor for the last 7 years, former law clerk, U.S. Supreme Court and U.S. Court of Appeals, has his law degree from Harvard about 12 years ago. Let's listen to his argument on behalf of the Haitian refugees.
Good morning, Your Honors. I'm Michael Ratner, and I want to introduce Harold Coe, professor at Yale Law School, member of the Bar of Connecticut, and at this time I'd like to move his admission pro hac feature.
Granted.
Thank you. May it please the Court, Your Honors, my name is Harold Coe. I represent the Haitians and their lawyers. Let me clarify some of the confusion that's just been generated by making 4 points.
Well, before you do that, can you respond to Mr. Singer's proposed schedule for expedited appeal? Do you agree with that or not?
Your Honor, the state is denied. We do not oppose the expedited briefing schedule, with one caveat that we would prefer all arguments to be late the week of May 4th. I have some commitments to my students that I'm not trying to break.
but the briefing schedule is fine by us if the stay is denied.
Suppose it's granted.
Pardon, Your Honor?
Suppose the stay is granted.
Then we'd like to do it quicker, Your Honor, because of the irreparable harm that we would face.
Students be damned.
No, the students... Your Honor, the students would force me to do it faster. Let me point out first that the government has mischaracterized the similarity between this case and a completely different case that was decided several weeks ago. The relief that we request is extremely, and the grant is extremely narrow and limited. It does the government no harm. Secondly, if a stay is granted, our clients will suffer irreparable harm and immediately. Third, the public interest is decidedly in our favor. And fourth, the government has made absolutely no showing of the likelihood of success on the merits. When to the contrary, Judge Johnson, after 3 days of oral hearing, submission of written testimony, oral testimony, detailed findings of fact, and extensive opinions, found that we, not they, have a substantial likelihood of success on the merits. Let me make it clear with that issue here. We're not challenging the Haitian Integration Program. We're not challenging the President's power to conduct foreign or military policy. We're not seeking to interfere in any sensitive executive branch functions. We're not, and this is what clearly and completely distinguishes Landon versus Placencia, we are not asking that our clients be allowed to enter the country. We're not even seeking to block re-screenings, interviews, or repatriations so long as they're conducted consistent with due process and with the right of counsel. And that is for people who have been found to have a credible claim of asylum. Repatriations are going on now. Since April 6th, some 600 screened out people, namely people who didn't have a credible fear of asylum, have already been sent back. And at the moment, we're not challenging that. All we're saying, and it's quite simple, is that lawyers and clients have a right to talk to each other. And especially that is true in a unique case like this, where the clients are people who have committed no crimes, who are being held incommunicado in custody on territory that is subject to exclusive U.S. jurisdiction and totally subject to U.S. authority, and who have specifically requested representation by our lawyer clients. Now, turning to the first factor, the irreparable harm, we believe that the case against the stay is completely made by an examination of paragraphs 23 and 24 of Judge Johnson's preliminary injunction opinion.
I don't think the government relies on anything other than that there is no possibility of success on the merits.
Pardon, Your Honor?
I say I don't think the government is relying on anything for the basis of their motion other than the fact that there's no possibility of success.
I think that's right, Your Honor, and under the circuit's state standard, Hilton versus Brownsville, the Eastern Airlines case, they can't make out their case just based on the likelihood of success on the merits. In fact, we have a likelihood of success on the merits, so they have made none of the showings that are necessary.
You're not impressed by the reaction of the Haitians to the Supreme Court's decisions and the District Court's decisions and so forth?
Your Honor, this is the illusory magnet effect to which they make considerable reference and on which they will, and I should continue to rely on extra record affidavits that were never examined by the District Court. On that point, in finding of fact number 28, Judge Johnson examined some of this information and found that any magnet effect was inconclusive. They had not shown that that's clearly erroneous. Secondly, and equally important, all that the preliminary injunction does is it restores the status quo as of 2 months ago, which is when the Solicitor General represented to the Supreme Court that any Haitian refugee who has a credible fear of persecution would be brought to the United States and given asylum procedures with full procedural protections, namely a right to counsel and a attendant procedural right. Now what happened is 5 days after the case, and this obviously obliterates their claim of any kind of race judicata or collateral estoppel because the circumstances have changed specifically because judicial oversight ended. 5 days after the Supreme Court denied cert and they thought the judicial oversight was over, they changed the policy and started re-screening people on Guantanamo without lawyers. And the net result of that, all we're saying is that the preliminary injunction simply holds them to the promise which they were held to and made to the Supreme Court 2 months ago and are now trying to walk away from. And any magnet effect of knowing that people would have the right to lawyers would have been created 2 months ago when the Haitians, according to their analysis,
read what was going on and determined that they should come to the United States because they might be screened and didn't have lawyers. Now, I think the most important point about the magnet effect is that they claim that Judge Johnson's preliminary injunction has had some kind of pull effect, and they completely ignore the push factors. Other things are going on here, Your Honor, besides a judge's ruling in Brooklyn. In Haiti, in the last few weeks, there has been a collapse of an international plan to reinstall President Aristide. There's been violence. There's been threatening of Supreme Court justices, beating of people in the streets. And as they conceded their preliminary injunction hearing, Castro expelled into waters later to be picked up by the United States a large number of Haitians who had originally come to Cuba. They have made absolutely no showing that any Haitian has been wronged here because of Judge Johnson's order. And nor do we think they can make that claim. In fact, the main statistics they cite would have required someone to hear about the order at 6 o'clock, which was the day that the order was granted, immediately jump into a boat and arrive sometime early next morning, which is actually impossible because it takes 1 day to get here. So we believe that the magnet effect is a total sham.
This is all very interesting, but bottom line, which I assume you're going to get to pretty soon, is you want to stay granted and the appeal expedited.
No, Your Honor, we want to stay denied.
The other way around.
Yeah, and the appeal expedited.
Now, why don't you say that?
Your Honor, we want to stay denied and the appeal expedited. And the reason, Your Honor, is because there's irreparable harm. If the court were to grant the stay, tomorrow, 34 people who are being held here, who have credible fears of asylum, would be sent back. The district court found that in its findings of fact, paragraphs 23 and 24. They are being held here entirely because of the court order. They would be sent back to what they call conditions of death or persecution. They would have never seen a lawyer. They would never have had an opportunity to make their claim. They would never have had an opportunity to make out an asylum claim. They would never have the opportunity to talk to lawyers who they themselves would try explicitly for retaining. Now, turning finally to the legal argument.
Now, before you do that,
I don't think it's necessary, Mr. Coe.
we've got two members of this panel, graduates of Yale Law School. I think we very high respect for your ability.
Your Honor, we're still trying to overcome any hostility you might have to Yale professors.
Well, a little bit of humor, and we might explain that. All of these judges who sit on the Federal Court of Appeals, all three of them, are Yale graduates. This is a Yale law professor. The petitioners asking for the stay here are actually lawyers and professors and students from Yale Law School who represent the Haitian refugees. Though it is a bit of a fraternity, I suppose one might say, I'm sure that these judges would act independently based on the law and fairness and equity, regardless of who graduated from what law school. We'll be back in just a moment with the decision of this three-judge Court of Appeals.
The 1964.5 Mustang, a classic car that took the country by storm. Now you can own a stunning replica of the design of this American favorite that is actually a working telephone. Introducing the 64.5 Classic Convertible Telephone, a meticulous recreation of this famous design that is both a valuable collectible and a one-piece telephone. This FCC-approved phone features a tone pulse option, last number redial, a non-slip tire base. It's hearing aid compatible, and when someone calls, the headlights flash and the horn honks. The Classic Convertible Telephone is perfect for home or office and makes a great gift. The Classic Convertible Telephone is available through this exclusive television offer for a limited time only for just $29.95. So to avoid disappointment, order your 1964.5 Classic Convertible Telephone now.
To order your 64.5 Classic Convertible Telephone, use your credit card and call toll-free 1-800-641-3377 or send check or money order for $29.95 plus $4.85 shipping and handling to the address on your screen. Choose from either red or black. Call 1-800-641-3377.
On July 1st, CourtTV was launched with a commitment to airing our nation's most important dramatic trials, wherever and whenever they happen. We've assembled the world's best legal journalists whose highest priority is fair and accurate reporting. We're proud of the work we've done. However, we know that from time to time, we make mistakes.
If you believe that we've gotten something wrong, write to me. We'll fix it quickly and candidly. In fact, we'll give all corrections the same on-air prominence that we gave to the original telecast. And if you have any comments about the trials we're covering or the way we're covering them, I'd like to hear about that, too.
Write to Stephen Brill at CourtTV, 600 3rd Avenue, New York, New York, 10016. Or call 212-973-3383. At CourtTV, we care passionately about getting it right, even if that occasionally means admitting we got something wrong.
Let's go back inside the Federal Court of Appeals. There are 3 judges who sit on that Court of Appeals. The Honorable George Pratt, however, is the chief judge, and because this is an emergency hearing, the law professor you just saw responding to an emergency request by the Immigration Naturalization Service. They're asking that this court overturn, essentially, the lower court ruling that said Haitian refugees are entitled to legal counsel. They're asking for an immediate order because they say irreparable harm will result unless something is done in an emergency fashion. And so this 3-judge panel, acting immediately, renders its decision.
Unaffected by any hostility that might or might not exist, we're going to deny the motion for stay. We'll expedite the appeal formally to the week of May 4th, but request the clerk to set it down for either May 7th or May 8th.
Thank you, Your Honor.
Thank you. Before we take up the remainder of the day calendar, we'll take a short recess.
And so here is the decision. Just happened yesterday, shortly a few minutes after the hearing itself. 3 judges on the U.S. Court of Appeals refused to grant the government's request to hold asylum hearings without providing lawyers for the Haitian refugees. And so, in other words, Carol Schlitt, as I understand it, these lawyers will then travel down to Guantanamo Bay, Cuba, to provide immediately counsel and advice for these Haitian refugees who are waiting for their hearings on political asylum into the United States.
Yeah, I think a point to be made is not only these lawyers, but also these law students.
Sure.
These are law students from Yale who are part of a clinic on immigration law, and they're going out to Guantanamo Bay. They've already done that as part of the discovery procedure, and they will be going both to provide counsel and to be there to interview INS and officials and also the clients who are there.
Do a lot of legwork, a lot of background
Absolutely.
work, checking facts and so forth, getting the information from the refugees,
That's
which can't
right.
be an easy thing to do.
Absolutely, and these are things that are very difficult, and that these cannot really be done by the clients themselves, because often they don't know what facts are legally significant. And if you've gone to law school and have some background in this, and that's really why they need counsel, because people really don't know what in their background is going to be part of a case for persecution or not.
Yeah.
And so this is very important, what's going to be happening over the next few weeks.
Well, the Yale law professor made a couple of pretty good points. First
Yeah.
of all, he said this, as I think we had said, it's really a stretch to say that just because you provide counsel to these individuals doesn't mean that it's going to send an immediate signal to every potential Haitian refugee on the island country that come on over to the United States because you're going to get counsel for a political asylum hearing.
Right.
Counsel is important, but it's probably not worth risking your life in the open seas in a tiny boat. So that was almost immediately dismissed by the Yale law professor. The second interesting point was that really this isn't costing the United States government anything. All volunteers from Yale Law School.
Right, people who are working as pro bono attorneys like myself, people who are working in this area who want to go down to be of some assistance. And I think that it's not a matter of the United States government having to expend a tremendous amount of cost, that people will go down, law students, lawyers will go down to be of assistance to make sure that the United States lives up to its own constitution, which is to provide due process and to have counsel provided for people who cannot afford counsel.
We've got a quick interview coming up in just a moment, but what's your reaction to the Federal Court of Appeals ruling here? You know, I always think that any appellate court is reluctant to overturn a lower court, and what might be the reasons?
The reasons, I think, is because in the lower court there were 3 days of testimony. There was much more that went on, and that Judge Sterling Johnson in the Eastern District of New York, was able then to get much more information, and that his opinion opinion should not be easily overturned. And I think it was heartening also that these judges saw that very clearly, that they decided quickly, and that, as you saw, it was not a long procedure. It was pretty obvious sort of the way it should come out, and I think it was heartening the way it did come out.
Yeah. Harold Coe is the law professor who represents many of these Haitian refugees in the Haitian Centers Council up at Yale Law School. We had a chance to talk with him, our reporter, David Bookstader, shortly after the decision was reached.
Well, we're delighted because our clients were in jeopardy. Had the court granted the stay, 34 people who have been found to have a credible fear of persecution would have been sent back to Haiti tomorrow. They're going to be held here at least until the appeal is argued, and we're confident we're going to win that too.
Can you tell me a little bit about the medical exclusion rule that the government was trying to use to deport these people immediately?
Yeah, there are about 200 to 400 people on Guantanamo who are suspected of having the HIV virus. We don't know if they actually all do. We think that troublemakers are also put into that group. Now, if they have a well-founded fear of persecution, they have a right to come in if they can make the medical exclusion waiver, and there are several grounds for doing it. One is to simply point to the fact that they have family members living in the States. Another possibility is to show that they've lived in the States before. Another possibility is to show that they are trying to go somewhere other than the United States. Now, what the government was saying was that those people should be sent back to Haiti, and the only point that we were making was if they had a lawyer, they might be able to make the case to go somewhere else. But they don't want to go back to Haiti. If they go back to Haiti, they're going to be persecuted, and we have evidence that some of them have been killed.
Is it your position that all Haitians who want to immigrate to the U.S. should be allowed in then?
No, not at all. Haitians shouldn't be sent back to conditions of political persecution. There's no reason to send them back, and that's the real point. Now, they have to go through the ordinary process to be admitted, and some of them will be admitted and some of them won't. But the point that we're making is, when the situation in Haiti is so dangerous, why send them back now?
What do you think the fate of those 34 might have been if they were sent back tomorrow?
Well, we had a case of a woman named Marie Zet. She was sent back to Haiti by accident. She protested, saying she should have been sent to Miami. And when she arrived back, her relatives reported later she was killed in her bed by the police. And we think that would have happened to at least some of the 34.
Just a final question about the military base in Guantanamo. It's your position that it is U.S. soil in a sense, and therefore these Haitians are entitled to counsel.
Guantanamo is a very interesting place. It's subject to the exclusive jurisdiction of the United States. The district court, Judge Johnson, found it's a relatively open base. It has a McDonald's, it has a Baskin Robbins. There are a lot of people walking around there, doctors, priests, piano tuners. Jacques-Yves Cousteau is there, everybody except lawyers. And the real question that we're asking is, why are the only people who are being excluded the people who might help these people stay or be prevented from being sent back?
So you felt in this case it was a sense of double standard?
Yeah, we think it's a double standard. We found a very interesting piece of law. I think you have to understand the government's position here is that these people have no rights on Guantanamo. They're not persons, they're objects, and they can be treated any way they want, the government wants. The Justice Department's own General Counsel's office issued an opinion which said that a law called the Anti-Slot Machine Act applies on Guantanamo. And the question we're asking is, why does the Anti-Slot Machine Act apply in Guantanamo but not the First Amendment or the Fifth Amendment of our Constitution?
And I think the court today decided that, or felt that the Fifth Amendment did apply here and agreed with you.
Well, the court's ruling says that they didn't give much credence to the government's claim that they're going to win the case. They had to make that case, and they didn't.
Bookstader with an interview with Harold Coe, the law professor who successfully argued this case yesterday before the Federal Court of Appeals. Carol Schlitt, you know a lot about what has happened because you represent a Haitian refugee. There have been some documented mess-ups. These are people who arguably really do need counsel because mistakes have been made ever since the flood of Haitian refugees to Cuba, the United States, Guantanamo Bay.
Yeah, in fact, in Washington last week on April 9th, there was testimony in front of a subcommittee of the House, and they talked about some of the screw-ups that have been actually happening with the INS files. Over 1,000 files have been lost. 54 people who were supposed to go, who were supposed to be allowed into Miami because they had passed this initial hurdle and had shown a plausible claim for political asylum were in fact returned to Haiti, and that 50 people who were screened out, who were supposed to go back to Haiti, were in fact allowed into Miami. One of the people who was returned to Haiti, in fact, it's been documented, who was supposed to have been actually allowed to come into the United States because she had a plausible claim for political asylum, was shot when she returned to Haiti. So you do have these terrible, mishaps where people are being returned who should have been allowed back into the United States.
Yeah, that is a shame, and hopefully that sort of thing won't happen again now that they have legal counsel. And on a happier note, if Professor Coe says that there's a McDonald's in Guantanamo Bay, it must be American territory. They should have lawyers as well.
Yeah, and a lawyer can make a difference.
Yeah, I think you're absolutely right. Thanks for being with us. We appreciate your knowledge and expertise on the subject matter. Hope you'll come back.
Thanks very much.
When we come back, we're going to be switching courtrooms down in the Atlanta, Georgia area. This is the case a decade later of the Atlanta child murders, asking that the convictions of Wayne Williams be overturned. Don't go away.
For the latest verdicts from trials seen on Court TV, call Court TV's verdict line at 212-973-6791.
Wait a minute. You're just pushing that harmful dust right into your electronic equipment. Now that's a man-sized machine, but how do you intend to clean that expensive light fixture? Introducing MiniVac, the amazing miniature cleaning system designed to take on hundreds of chores no ordinary tools can handle. MiniVac cleans away dust from camera lenses, computer keyboards, figurines, or stereo equipment. MiniVac's powerful motor vacuums away dust and dirt. It comes with 2 wand attachments, 2 ultra-soft brush nozzles, and a reusable vacuum bag for dust collection and disposal. Keep one in the car for cleaning along the dash, steering column, stereo, ashtrays, and seats. MiniVac is perfect for removing dust and debris from pictures, models, and those impossible-to-reach crevices. MiniVac operates on a single 9-volt battery or AC adapter. In this special television offer, you get MiniVac with straight and curved wands, 2 ultra-soft durable brushes, reusable vacuum bag, plus a convenient storage case for only $19.95. Here's how to order.
Credit card and COD customers call toll-free 1-800-641-1155 or save COD fees by sending $19.95 plus $404 shipping and handling to MiniVac, P.O. Box 4942, Omaha, Nebraska 68104. Or call 1-800-641-1155.
It's showtime. Showtime. Hey! Whoa!
Outdrive your partner with this half-hour instructional video, free with a 1-year subscription to Golf Digest, just $19.77. Call 800-641-3377. Imagine this video and Golf Digest. Call 800-641-3377.
And welcome back to Court TV. I'm Greg Jarrett. Our next trial brings us back to the frightening headlines of the early 1980s. For 2 long years, July of 1979 through June of 1981, the Atlanta area was gripped with terror as children and young adults, one after another, turned up missing, then murdered. 2 years after the first victim was discovered, the number of bodies reached 28, and a 29th child was still missing. And a young man by the name of Wayne Williams was arrested. He was charged and convicted eventually of 2 of those murders. Police later on linked him to over 20 others. As of today, 5 of the cases remain unsolved. And to this day, Wayne Williams maintains his innocence. But now he has a new team of lawyers, some famous lawyers, and they claim to have discovered new evidence in the case, evidence linking the Ku Klux Klan to the Atlanta child murders. And in just a few moments, we're going to begin as the attorneys for Wayne Williams ask Judge William Craig to set aside their client's convictions and life prison terms, laying the groundwork for a new trial. To begin hearing we have a background report by CourtTV's Steve Johnson.
It was Atlanta's long nightmare, and it began in July of 1979 when the bodies of two young black children were found here near Niskey Lake Road in southwest Atlanta. Like clockwork, the scenes were repeated, the flashing lights of emergency vehicles, the crowds of reporters and photographers, and the body of another black child added to the list of the city's missing and murdered children.
For a while there, in the winter and spring of '81, it seemed like a new body was showing up every few days. It was dizzying. It was like this hallucination as a reporter, because you just were consumed by these stories. I mean, one body and the aftermath of it and the funeral of it overlay the next body and the aftermath and the funeral of it, the reaction to it and speculation on it.
As more children were reported missing, citizens groups began to join the police in the search.
We expect to have between 200 and 250 police officers combing this area shoulder to shoulder. And again, I emphasize heavily wooded, very densely wooded area. And we're going to give it every bit of attention that can be given humanly possible.
I joined one of those searches about 10 years ago. The crowd was about half black, half white. The mood was serious. We didn't find anything, but we at least had a feeling we were doing something to help stop the killings. Local authorities appealed to the federal government for help, and eventually the largest task force in U.S. law enforcement history was formed to investigate the slayings.
There was an absence of what appeared to be a struggle to get to the children who had been killed, and one of the things that evolved was the possibility that here we had someone who somehow gained their trust. So the question was, is someone who wears a uniform? Is it a police uniform? Is it a firefighter's uniform? Is it a media person?
But still, young black children continued to disappear. From January to May 1981, there were 12 apparent victims. The killer seemed to have a sixth sense of how the police were operating. When investigators reported that they had recovered valuable evidence from the bodies of several victims, he changed his disposal method. Now, bodies began to appear floating in Atlanta's rivers, where the water would wash away most of the clues. To counter, authorities assigned police officers to hide under area bridges and wait. On May 22nd, at 3 a.m. in the morning, two officers hiding underneath the Jackson Parkway Bridge heard a car slow down. Then they heard a loud splash, and the car drove away. The driver was stopped and identified as Wayne Williams, a 23-year-old music promoter and freelance TV news photographer. Police say he told them he had thrown garbage from the bridge. Williams later denied throwing anything. 2 days later, the body of Nathaniel Cater was found floating in the Chattahoochee, a short distance downstream from the bridge. Williams was taken here to the FBI headquarters, where